Hello, everybody. Thank you for joining today. My name is Aníbal Suriel, and I'm the managing partner at Solidity Law. We're a Miami-based law firm focused on emerging tech practices. This includes blockchain, anything to do with securities laws, data privacy, intellectual property, of course, and anything pretty much a startup nowadays would need, right? So today, granted that that's what my law firm focuses on. I thought it would be pretty apt to speak about the copyright implications of selling AI generative art, right? I think we all were pretty astounded by how quickly AI came in and sort of changed the picture as to generating. Just look at the artwork that I have up there. What I did was just put in exploring copyright law and selling AI generated art into DALL-E, and it spit out all of those different images. I had to put in no extra time. This helped me put my presentation together pretty quickly, especially since I'm attending to a lot of cases, so this was definitely helpful for me. But it is pretty important to explore what it means to sell art that you had no real role in creating other than, putting in the prompt, right? So just looking at the numbers, I thought it would be pretty interesting to look at how big the AI generative market is to begin with. If we could see from the graph itself, back in 2020, it was about 2.4 billion, 2021, 2.5, and we could see where it is headed in the future. And if we look a little closer into it, right, we could see that media and entertainment, where we can assume that NFTs and all of this art is located, right, makes about 15 to 20% of the market. So it is a pretty big chunk. Thank you to Grandview Research for all of this data. But I wonder whether they looked at, what about the losses as to revenue lost on not being able to, enforce your own copyrights, or what happens when maybe you're sued because one of the images these applications spit out were a little too close to something that's copyrighted out there already, right? So again, what are the commercial implications of selling AI-generated art? To be able to answer this question, I think we need to start with a smaller question, right, and see what is copyrightable in the U.S. in the first place, right? So if we look at the Copyright Act of 1976, it's pretty straightforward in that the gist of it is that the work itself needs to be original, and it needs to be, fixed in a tangible medium. And this covers artwork, it covers audio work, even dances, all of these good things. Those are the things that you could go to the Copyright Office to go ahead and register. That way you can enforce your own copyrights and make sure that nobody else is infringing on your rights, because at the end of the day, this is a field where you need to go in and make sure that you're protecting your own copyright. There's no police officers out there making sure that your copyright's protected. This is all on you, right? So that being said, thankfully, the Copyright Office did answer this question as to whether AI-generated art is copyrightable. This came out about 2 months ago, but the gist of it is, again, that the work itself needs to have human input. There have been a couple of cases in the past, such as there was this one case where a monkey took a picture, and they were sort of exploring the question as to whether that itself is copyrightable. The answer was no, because if you look at the Constitution and the way it's worded, at the end of the day, it's about that human element in that work itself, right? So knowing that if you're using AI, okay, so the next question is, if I'm going to use this, how do I use it so that I make sure I'm protecting my own copyright, or I'm protecting myself against potential, litigation for possible infringement, right? What the Copyright Office came out with were suggestions as to making sure that there is that human element in your work. If you're going to use AI, make sure that you take the time to go ahead and edit it as much as possible, put in your own input, make sure that it's expressed in a way that a human would, and that is very identifiable and differentiated from other artists out there, right? Just make sure that you take the time to put in that element, right? Because what ends up happening if you're selling work that is not copyrightable You cannot enforce your rights there. You're sort of running the same sort of business model that maybe Zara would, because Zara goes ahead and, you know, puts out a lot of clothes that actually do look like a lot of the current pieces out there, right? It's a fast model, and it's hard to keep up with, and it's just completely exhausting, right? So maybe, you know, you could form your business around that model, or you could just take the time to make sure that what you are putting out there, you know, is copyrighted, well, copyrightable to begin with, right? And I did want to point out, and I thought it was an interesting thing to, I guess, sort of touch on, was how these models come together in the first place, right? You have your data scientists who go ahead and put together the data sets and essentially train a model on thousands, if not millions of different pictures. With these data sets, you have the AI that goes ahead and trains and picks up on the different art styles, picks up on the different colorings, et cetera, et cetera. And when you put in your input of, I want, you know, AI generative, okay, I guess we don't have the presentation, but, you know, if you put in your input, what it does is that it goes ahead and predicts what exactly the output would be for what you had inputted, right? So again, that's where the whole, your potential for infringing others' copyrights come into play. Yeah, I don't know if anybody has any sort of questions. I kind of
have a question for you.
Go ahead.
The notion about what you had up there about the author has to be, you know, authors can't be non-humans under the copyright law.
Yeah.
And maybe it's just a particular section, but we know that in the work for hire context, right, a corporation, a company, a non-human can be deemed to be the author. So 2 questions. One is, how do you square that? And this just popped into my head while you were thinking about it, but if you had a website like the one you're working on, could that website's terms and conditions include a work for hire agreement so that the AI engine, whatever is creating it, is agreeing with you in a written form, as you need for work for hire, that it's a work for hire and therefore perhaps you could own it that way?
Yeah, no, great question. I'll slide back to the image. Yeah, the slides with the images themselves. So these are from DALL-E, and they have that open source license.
Is it D-A-H-L-I, like the artist?
D-A-L-L-E. This is from OpenAI instead of ChatGPT. This is more their generative art sector. But what you're asking is, at the end of the day, when it comes for work from hire, there's still a human creating that work, and what happens there is it's a contractual mechanism in that you are going ahead and assigning your copyrights to the corporation. So sure, corporations aren't people, but they could still own assets, and that's how that mechanism works. So when you go ahead and have, if you're creating an AI generative art engine yourself, make sure to put into the terms and conditions that either, you know, you are licensing or you're assigning these copyrights to the individuals. That way they can go ahead and have some sort of assurance there. But remember, there's still the question as to whether that that content is copyrightable to begin with. Had OpenAI not issued those, you know, open source licenses, you know, are they the creators? That's always a big question. Is it the machines themselves? But what about me? I put in the prompt to create that image in the first place. Don't I have some say there? There's a whole bunch of different questions that are still out for debate. But of course, as a lawyer, I'm here to tell you, you know, there's always the least risk-averse way of approaching something. Yes?
2 questions. The first is, I was wondering what you make of this new copies writing category that Getty Images is spearheading about the mining of data sets, and so where they're not actually paying for the rights of any one particular image, but the ability to really train a model on the entire data set. The second question is, so many works of art generated by AI are done in collaboration with an artist. It's not an all or nothing thing. It's to a degree. So how do you deal with AI artworks where there's the hand of the artist in it very visibly, but also distinguishable and separable as well, the AI component of it?
So touching on the last question, the Copyright Office did come out and say the copyrightable portions of your work are those created by the humans themselves and not the AI-generated content. So maybe one form of expression in that piece of art was done by the AI. Maybe that won't be copyrightable, but again, it's on a case-by-case basis. You have to take in the file. It's a whole process, right? To touch on the first question as to Getty Images and whatnot, I did listen to a podcast this morning in preparation for this speech and everything like that, and that might be where the entire model is headed towards, because there are a couple of lawsuits pending as to artists not really too happy about these AI data sets being trained on their work. So the way I predict things are going to go, right? Because we have a Congress that does not want to, sort of create these new laws or amend prior laws, is that things will be resolved in the court. And if things are resolved in the court, what's going to happen is that, the small players are going to lose, and it's going to take the bigger companies like Google, Getty Images, and everything like that, licensing their images to go ahead and create new AI generative engines that work solely off of licensed images. I believe it would, because one big question is whether whether a derivative work was created for the purpose of generating profits. If it's not, if it falls under the fair use doctrine, things like that, it does help you out. Any other questions? Yes. That is a good question that I have to think about, and I'm happy to sort of chat with you after. I don't know if I'm good on time. I can answer. Okay, so I mean, in creating your own art, are you using the AI generation? Are you just sort of creating these things in very traditional methods, and you're sort of afraid of what's going on with that tech, or what's your? Yeah. So, I mean, in that sort of situation, the best practices would be, if I were you in your shoes, I would create probably most of the art yourself, right? And then use that AI to go ahead and enhance it. Where at the end of the day, if a normal person were to take a look at it and see that this is your work compared to your prior works, you should generally be protected like that. If you wanted to take it a step further, you can always go ahead and register the copyrights with the Copyright Office. A lot of the times, and to be completely honest, I don't tend to recommend individuals to go do that, because you do have an inherent copyright protection under common law and everything like that. Really, you need to go register when you are likely to have any sort of lawsuits, or if you're dealing with, highly public images and things like that, where you are likely to have to register. Because if you don't register and you want to sue somebody, you're going to have to register. The Copyright Office otherwise doesn't have any other mechanism. I do know they have different initiatives, as actually copyright litigation nowadays can cost anywhere up to $278,000, right? That's not something that the little guy could afford. They did come out with a different dispute resolution mechanism for situations like that. But that dispute mechanism doesn't allow for injunctions, right? And injunctions are what allow you to go to somebody and say, you cannot continue doing this practice. And that's, to me, is what's most important. But time to wrap it up. Thank you, guys. Thank you.
Thank you, Aníbal. Good job. Give that to Jen.